Everyone. I'm Bacardi Jackson with the Southern Poverty Law Center, and it is indeed a pleasure to have you joining us here today. We are here as Public Funds, Public Schools, which is a national campaign that came out of a collaboration from the Southern Poverty Law Center, the SPLC Action Fund, the Education Law Center, and Munger, Tolles, and Olson. And our goal is to ensure that all public funds for education are used to maintain and support public schools. And we do this work so we can protect and promote public education using a range of tools, including litigation, advocacy, and research. We are seeking in this work to counter a significant and concerted effort that has been underway for quite some time that seeks to undermine public education by promoting the use of public funds for private education, including through various kinds of private school vouchers, which you'll hear a lot about today. We have the pleasure of having an amazing expert with us. Before we get started, I want to just go over a couple of things. This is the first of the webinars that we will be doing, the first in our series, and we have many more to come that we hope you will also join us for. And to do that, all you have to do is go to our website. I urge you to do it right here, right now. No better time than the present, which is PFPS.org, PFPS for Public Funds, Public Schools.org. So please sign up there and you'll get notifications about our other webinars that will be coming soon. If you have any questions for our speaker today, we ask that you will put those in the question and answer section, not in the chat box, but Q&A. And we will address those questions at the end of the webinar with Dr. Mead. Just so you know, as Nicole already announced, this webinar is being recorded and it will be made available for other people to view again at the website pfps.org. So without further ado, it is my pleasure to introduce to you Julie Fisher Mead, who is a professor in the Department of Educational Leadership and Policy Analysis at the University of Wisconsin at Madison. Dr. Mead is a leading expert who researches and writes about topics related to the legal aspects of K-12 education. Her research centers on legal issues related to special education and legal issues raised by various forms of school choice, including charter schools and vouchers. So please take it away, Dr. Mead. And thank you for being with us.
Well, thank you, and thank you for that very kind introduction. And I'm going to share my screen, so let me do that quickly. So it is indeed a delight to be here, and I appreciate the opportunity to talk with you. Much of what I'm going to talk about today is not something that I can actually claim ownership of. It's really things that people have talked about for a very, very long time. The relationship, of course, between public education and democracy. And, oh my goodness, there we go. Sorry, different way of advancing slides. What I mostly want to talk with you today about is, in fact, these two questions. So thinking about the values and principles that make public education so essential to a strong democracy, and then to talk with you about how we can collectively describe and defend those values when we're supporting public education. Among that, I'll take a particular amount of time at the end of the talk really to show and talk about how privatization, those ideas of vouchers, for example, have an implication for public access, for discrimination, and for making sure that, in fact, all kids can participate in public benefits. But again, this idea of the linkage between public schools and democracy is certainly not new, and I'm certainly not the only person that has made this observation. In fact, right back to the founding of our republic, it was recognized that, in fact, we had to have an educated citizenry if this experiment in democracy was going to work. This is Horace Mann, who's usually credited with being the intellectual architect of the idea of public schools, and really pushed forward this notion of universal public schools for all children. And as you see from his bottom quote there, considered public schools, in fact, the greatest discovery made by man. As you heard in the introduction, my thing is school law, so I couldn't resist, of course, including our seminal case in Brown versus the Board of Education, which, by the way, we just celebrated the anniversary of on Sunday. And in Brown versus the Board of Education, if you think about what those litigants were asking the Supreme Court to do, and you boil that down at its base, what they were saying was, hello, we are part of public too. We should be treated as part of the public in a manner equal to everyone else that's part of the public. And of course, in rendering their decision, the Supreme Court said that we have to recognize, as you see in the red print, the importance of education to a democratic society, and also that is in fact the very foundation of good citizenship. But beyond all of the great thinkers and the various professors that I've had, colleagues that have informed my thinking, probably the person who is most informed my thinking on this idea of public education and its relationship to democracy is this man. That's my father, Wilson Henry Fisher. He and my mother raised 8 children. I'm number 7. And this picture comes from my senior yearbook, so I'll let you do the math. But at that time, Dad was the president of our school board. And believe it or not, he really did talk at the table about the importance of service, the importance of democracy, and how education, and public education in particular, influenced or was necessary for a thriving democracy. And from him and all the other people that I have learned from and with, I've come to think of public education as embodying 4 criteria. So really an answer to the question posed at the top. What, in fact, is the public part of public education? And that's public purpose, public funding, public access, public accountability to communities, and public curriculum. And I'll talk about each of these in turn. So the public purpose, that's that recognition that education is not a private enterprise alone. And in fact, we all benefit from an educated citizenry. So of course, I have an interest in my own education. I have an interest in my children's education, but I also have an interest in the education of my neighbors and my neighbors' children, because we are truly all in this together. And I benefit from the education of everyone around me. It's essential then to democracy if we're going to be informed voters making choices together about what we want our communities to be like. And so in order for everyone to be informed and weigh in, we need to have a way to have universal education. The public purpose of education is also about the notion of the commons. And the commons is a recognition of the variety of services that governments do, because we have long figured out that it's better to do them collectively than individually. So public education is part of the commons, so are our public police force, public fire department, the roads that we drive on, the parks that we visit, and a whole host of other things that we do that are part of the commons. And again, as a law person, one of the things that I find really remarkable is that if you think about state constitutions, those constitutions, all 50 of them make a provision for education. Why is that so remarkable? Well, remember what a constitution is. It's not just a dusty piece of paper, which they could be, but a constitution is literally the document by which a people, us, constitute a government. Say what the government exists to do and why the government is being formed. And when you think about it that way, the fact that all 50 states have said that a primary purpose of state government is in fact the provision of public education, that's really quite remarkable. I won't go through all 50 states, I promise, but I do have some examples for you. Here's Florida. So this is the provision of Florida's constitution, and notice that red word, shall. So in other words, this is not part of the job of the Florida legislature that's discretionary. It's a mandatory action that the legislature has to take care of. Likewise, here's an example from Indiana. Again, notice the word shall. It's a primary purpose for state government in Indiana to make and provide by law for a general and uniform system of common schools. My own state, Wisconsin, has something similar. The legislature shall, and again, it's a mandatory requirement, not a discretionary one. As an aside, I should mention that even in those states where state Supreme Courts have upheld voucher laws, the language in those decisions makes clear that, in fact, the provision of public education is primary and mandatory and obligatory on the part of state legislatures, and that, in fact, even when they've approved them, the voucher programs have been approved as a discretionary act. Big difference. Of course, if you have something that's that central to a state government, that's when we have public funding. We invest together on all of those things that are part of our commons. And it's, again, a mandatory expenditure, not a discretionary expenditure. And with that public purpose and public funding, we want to make sure that, in fact, the entire public has access to that benefit. So public schools have to serve everyone. They have to serve the whole public. If you were to come and take my school law class, I would walk you through a whole series of cases, really beginning with Brown versus the Board of Education and then up through the decades. And each one of those cases, there were groups of plaintiffs who came to a court to say, we're being excluded. Don't exclude us. We are part of public too. So we have court cases around granting access on the basis of race, granting access on the basis of for those whose first language is not English, making sure access is available to children who have disabilities, making sure that access is available equally on the basis of sex. All of those, again, hard-fought litigation to make sure that we understand at its core that public is an inclusive term of everyone. Public access is also there to try and structure this notion of a common school experience. The idea that if we are all together and have an experience together that brings us together, we could, as my grandmother would have said, learn to disagree without being disagreeable. Public access has also been guaranteed through a whole host of federal laws. And this is just some of those laws that make clear, in fact, that public education has to ensure that regardless of disability status with the first three laws, or regardless of status on the basis of race or color or national origin or sex, that access must be guaranteed, and in fact, no discrimination may occur. I'm going to come back to this, but I'll point out now, you'll see that there are three laws that have bolded section that say recipients of federal funds. That is, of course, a limitation of those laws because they only apply to those entities that have received directly federal funds. Fourth, then, is public accountability to communities. And this is in some ways, a two-way street. So we hold our schools accountable by the laws that we create. We hold our schools accountable by making them be responsive to, in fact, elected bodies. And we elect our neighbors to serve. We elect our neighbors to serve at all levels of government, at the local level with a local school board, for example, at the state level, your state legislature, your governor. If you're in a state like mine, you get to vote for the state superintendent of schools. At the federal level, you have the House of Representatives and the Senate, and of course the president, and all of those people have a role in educational policy formation. And of course, as a voter, if we are happy with the work that those representatives of ours are doing with regard to education, we vote them to stay in office. And by the same token, if we don't like the kinds of things that they're doing with respect to education, we can hold them accountable by voting in new neighbors to bring those ideas that we think are more important. Once, of course, we have those elected officials, they create a whole series of laws that structure baselines or expectations that we have for our schools. This is a non-exhaustive list, but starting, here's a whole host. of laws that have to do with, federal laws that have to do with education. And most states have even more laws having to do with education because education is considered primarily a state responsibility. All of those laws establish baselines. So what is kind of minimally acceptable, for example. So I mentioned my grandma, who was a one-room school teacher in southern Wisconsin in the early 1900s. And when grandma became a teacher, she had to pass a test and be 16. Now that's it. Well, over time, our state and many others, of course, have said that's not good enough. So we've raised the baseline of what it is required to be a teacher, and we require a college degree. We require the study of child development and child psychology and pedagogy and content matter. All of those kinds of things are ways that we establish baselines in the kinds of laws that we pass. It both sets direction and expectations for what schools are to do, and laws prescribe some actions. You will teach this and you will teach this other thing. And it also proscribes other actions. For example, here in Wisconsin, we prohibit corporal punishment. Altogether, all laws, all policy codifies values. It says at that time what the body politic, what the collective, the we, value and what we think is important. Which brings us to public curriculum, where we decide collectively what it means to be educated, what has to be taught, and what standards we're going to hold. I'm using my family a lot today. I will continue. I'll use my 3 daughters because they illustrate the point that we shift over time what it means to be educated and what standards we think are appropriate. So my oldest daughter, between my oldest daughter and my second daughter, our local school board added a new requirement. To graduate from Middleton Senior High School, you had to have a course in personal finance. The oldest one didn't, but the second one did, because ever so slightly, the school board redefined what it meant to be educated at that high school. Between daughter 2 and daughter 3, they added another requirement, 40 hours of community service. Again, very slightly redefining what it means to be educated. Of course, if I compare my education to that of my daughters, there are a lot of differences. For one, I didn't have to learn anything about computer literacy. When I was in school, the fact that we had a calculator was a brand new thing. So now, of course, we wouldn't consider a child to be properly educated if they didn't have some computer literacy skills, because as this Wisconsin statute lays out, it's dependent, what public schools provide in terms of curriculum is dependent upon a common understanding of what public schools should be and should do. And to continue, our state statute says that at a minimum, these 4 buckets or these 4 groups of skills have to be attended to in the curriculum for the schools, the public schools in our state. And I'll draw your particular attention, of course, to item C, citizenship. So then how do you describe and defend those values when you're supporting our public schools? Well, I think it's by using, again, just those aspects of publicness, because as we entertain or as states move to introduce other forms of publicly funded education, different from public schools, it is really those dimensions of publicness that we are using to purchase those new forms of schooling. And I think we need to ask ourselves collectively, are we willing, in fact, to use those forms of publicness as the currency to buy this new kind of education? Why? Because public schools serve everyone. Public schools are accountable. Public schools make strong communities. Public schools, in fact, are the cornerstone of democracy. But moreover, public schools work. You might not think that when you read the newspapers, but in fact, research has shown over and over again that public schools do work. I always like to highlight the work of Chris and Sarah Lubienski, who are professors at Indiana University now, and this marvelous book that they wrote several years ago, where they looked at 2 very large national data sets. And when they looked at that data, they found, despite what you might read in newspapers, that public schools outperform private schools, charter schools, and when you control for poverty, they even compare well internationally. To give you a little bit of flavor about what they did, sorry, I've got something in my eye here. They looked at, this is a graph from their book looking at 4th grade reading, and they were comparing to public schools. So let me explain how this graph works. So because the comparison is to public schools are represented by that 0 line, the red line that's in the middle of your screen. And so the idea graphically is that if a school, like the ones in the columns on the bottom, if the school outperforms public schools, the graph would appear above the line. And in fact, if the schools don't do as well as public schools, the graph would appear below the line. So what they showed was that if you looked at raw school achievement, and this is typically what's reported in the newspapers, so just the raw aggregate numbers, the average of person in this school, the average person in that school, it appears as though, in fact, all those schools outperform public schools. But in fact, that's a misleading statistic because you're not doing an apples to apples comparison, because the people who attend those different schools are not alike in terms of all their characteristics. So what the Lubienskys were able to do is they were able to use statistic to then control for those characteristics, so that they took a similarly situated person in the public school and a similarly situated person with the same kind of characteristics in the private school, and compared those two people who are more alike each other. And when they did that, notice how the picture shifts. In fact, now the graph is all below the line, and you'll notice these little dots, which means that the results were statistically significant, meaning they would not be explained by chance. So in fact, public schools do outperform all of those. Another example, this is from the same book, the 8th graders. You'll notice that again in the raw score, it looks the same in terms of above the line, but when you control and make sure that both folks are similarly situated, they're below the line or they're about the same. More recent research followed a group of kids from birth to 15, and what they found was that in fact there was no evidence to suggest that kids enrolled in urban schools and private schools did better. So back to that idea of, again, what's public about public education, public purpose, public funding, public access, public accountability to communities, and public curriculum. We have to think then about what happens when we introduce privatization. How does privatization then affect all of those things? Now, please don't misunderstand me. I'm not saying that the public system is perfect and that we don't have a lot to fix. We do. There is no form of governance that's going to make schools perfect. And education is one of those endeavors that we will never be satisfied. We will always be striving to do better, and as we should. But one of the concerns that we raise in this particular piece is how, in fact, privatization opens the door to discrimination, opens the door to spaces where public funding goes, but public access does not follow. And that's gotten a lot of press, if you will. Here's just some headlines over the years that have raised those same issues about the accessibility of various kinds of privatized educational spaces. And when I talk about this, often what I'll have is someone will say to me, oh, wait a minute, how can a private school take public money and then exclude some people? And then I'll have someone else will say to me, well, wait a minute, those private schools aren't breaking any laws, so what's the problem? And of course, both of those individuals can be right simultaneously. And the reason for that is that there are three phenomena at work. One is that federal law describes or defines discrimination differently in public and private spaces, and I'll explain what each of these mean, of course. The second is that state legislatures, when crafting their statutes that define vouchers and charters, have largely ignored the issue of non-discrimination. And third, because of the power to set what programs you're going to offer, that means that schools can dictate who comes to their schools while attracting some and excluding others. Before I talk through these three factors, though, let me just remind everybody about what privatization is. It's not only an educational issue. This happens in lots of spheres, but what's common is that it's the idea that you're using some kind of private entity to provide a public purpose, and that often it's based on market principles, and that you may even have the private individuals saying where the money goes rather than an elected body. When we talk about it in relationship to schools, we're talking about school choice. So we're talking about voucher plans, tax credit scholarship plans, educational savings accounts, and charter schools, predominantly those charter schools who are authorized by entities that are not elected school boards and are operated by private companies, particularly private for-profit companies. I'm also often asked the difference between vouchers and charters. So let me just lay this out very quickly. So voucher schools are private schools who elect to participate in a state's voucher program. No one compels the school to do so. They elect to do so if they want to, but they remain under private control. And as you'll see in a minute, federal laws apply very differently in those private schools, even when participating in a voucher program. Charter schools are a specialized form of public schools that are created by a contract, a limited term contract between an authorizer and whoever wants to operate the school. They have a contract that spells out, a performance contract that spells out what the charter school has to do. And if they fail to meet the parameters of that contract, their charter can be revoked or non-renewed. In exchange for being bound by that contract, they are relieved from some state laws and regulations, but charter schools are not relieved from compliance with federal law. These are the three main kinds of voucher, or what I call voucher-like programs. A voucher plan, where we set aside amount of money that is used for private school tuition. The second kind of creates a middleman, where the state sets up or endorses or recognizes scholarship organizations. Taxpayers, corporate and individual, can divert a portion of their taxes into that account, and that account then pays for tuition scholarships. And then the third is the education savings account, and that's when states typically take an average amount of state aid and put that into a parent's education savings account from which education expenses can be paid. So let's talk about those three phenomena. Well, the biggest one and the most important one, frankly, is this first one, which is that federal law defines discrimination differently in public and private spaces. And to understand that, you have to understand the 14th Amendment. So the 14th Amendment's Equal Protection Clause is that part of our federal Constitution that is the foundation for our ideas of equity and equality and non-discrimination. But notice those first two words, no state. It's a limitation on governmental agencies. It's not a limitation on private individuals. So in order for the 14th Amendment to apply, there has to be a state actor, someone connected to a governmental entity of some sort. Public schools have those state actors because we're created by the state legislature, we're operated by publicly elected school boards. The state oversees the whole system, so state action is there. So the 14th Amendment has a lot of sway in what can and cannot happen in a public school. The other thing I'll point out too is that the 14th Amendment also granted Congress the authority to enact legislation consistent with this rule, which is where you get that list of laws that I showed earlier and that we'll come back to. So that state actor issue is a big one because, as funny as it might sound, in a private school where you have no one connected to the state, it doesn't apply. So the Constitution doesn't apply. This is the reason why in 2002 the Supreme Court said that it didn't violate the Establishment Clause, because they decided that in fact it was an individual parent, private actor, saying where the child would enroll in school and spend that voucher, not a state actor. So in the absence of a state actor, the Constitution doesn't apply in private schools. Now, you might be wondering why she got a plus minus under charter schools. That's because there have been some debates, and there's even been some litigation where charter schools have argued that for some purposes they're state actors, and for some purposes, particularly when operated by a private company, that they are not a state actor. Those laws I mentioned before, again, they do apply to private schools, but they have limited or no application they do apply to charter schools, but limited or no application to private schools, even if those private schools participate in a voucher program. And the ones that are circled are those laws that have the recipient's trigger. In other words, they only apply if the school is the recipient of federal dollars. If they're not the recipient of federal dollars, then those rules don't apply at all. In addition, some of those laws have explicit exemptions for religious entities. So if a private school that participates in a voucher program is a religious school, it may or may not have to, they may not have to abide by all of the provisions of these laws as well. An example I think is helpful, and so special ed is a good one. So in public schools, including charter schools, kids are protected by a trio of federal laws: Section 504 of the Rehabilitation Act, the Americans with Disabilities Act, and the Individuals with Disabilities Education Act. And those three laws together make clear that public schools may not discriminate on the basis of disability. But it's what that means and what those statutes say that means that's really important. That means that all public schools have to evaluate all children they suspect of having a disability, even those who are in private schools. It means that public schools have to provide whatever special education and related services are necessary to provide a free and appropriate public education for an individual child, which means they have to go and get that service if that child needs that service in order to have an appropriate education. They have to provide some services even for children enrolled by their parents in private schools, and yes, even if they're enrolled through a voucher. And this idea that there's no rejection, that all children, regardless of the severity of their disability, have a right to that free, appropriate public education. In contrast, private schools only have to really comply with Title III of the ADA. Section 504 applies indirectly if they're participating in a voucher program. It's true that those laws do declare that those schools may not discriminate on the basis of disability, but what that means is different. What it means is that those schools only need apply reasonable accommodations and modifications to existing programs. So if a child goes to a private school, for example, a child with a disability, and needs a particular service, and the school doesn't have that, they can say to that child, "I'm sorry, but we can't serve you here. You can't enroll here." And by law, they have not discriminated because we define discrimination differently. They're not required to provide that child what that child needs. And so turning the child away is not considered discrimination in this sense. In other words, what the law considers discrimination in public schools and private schools are not the same thing. Secondly, is that idea, well, even if those federal laws apply differently and have a different kind of patchwork, how about the state laws? Well, the state law, both voucher and charter school programs, I call creatures of state law because they are whatever the states that created them say they are. And so a voucher program in Wisconsin is not the same as a voucher program in Florida, and a charter school program in Michigan is not the same as a charter school program in California. You get the idea. Whatever the state says it is what it is. And so the state defines the term, defines the rules, defines the eligibility, both for the individuals and for the schools that want to participate in a voucher program, for example. And they determine how the schools are funded, how the programs are funded. All of those kinds of things have their home in state law, but unfortunately, as research that I've done with Suzanne Eckes, who's also at Indiana University, we took a look at all of the voucher programs at the time we wrote this article, and in fact found that the state legislatures had not included comprehensive non-discrimination language into their voucher statutes. In other words, they had not made non-discrimination a condition of private school participation in the program. How about charter schools? Well, as I've said before, federal non-discrimination law applies, but the state laws often require that they declare that they're going to avoid discrimination, but haven't explained what that means. What does that mean in terms of how you market your program? What does that mean in terms of who comes to your program, particularly if you see that you have an underrepresentation of some populations and an overrepresentation of others? And they don't require, in fact, authorizers to consider those issues of non-discrimination either through the application process or through the renewal processes. And then finally, because private schools and again some charter schools have the authority to determine what programs to offer, and we're in this market system where we attract people, right? They have the ability to attract some populations while turning away others. As the special education example showed, there's a big difference between a mandatory action, you must do this because the law requires you to, which is where you are in public school land, versus you may do this if you wish to. So for example, services for children whose first language is not English is a requirement of public schools. It's not a requirement of private schools. Private schools can elect to do that, but they are not required to do that. A very different kind of context. In addition to that, we have what I call your most excellent promise problem. And that's where, you know, everybody's actually doing everything that they're supposed to do. So the parent may go to a charter school, and the charter school has perhaps never had a child who had a particular need, and so it wouldn't be fiscally responsible to have someone on staff for whom no one needed that particular expertise or service, so they don't. Parent says, I have a child with these needs. Do you have the expertise? The school says, well, no, but we make you our most excellent promise. If you come here, you will. Well, again, that rational parent may decide, I'm going to go to a school that already has that, and that's likely to be the public school. So it's not surprising that even though no one's anything wrong here, the charter schools tend to have fewer kids with special needs, both on the basis of disability and the basis of language learning. Again, because of that most excellent promise problem. So the issues that I think we have to think about are, in fact, those non-discrimination laws predate both vouchers and charters. And so they don't have really good application in this new context. I mentioned before that we had a whole series of court cases, costly court cases, where people had to litigate to have the recognition that they're part of public too. Do we really want to fight those legal battles again? To, again, have folks say, I'm part of this public benefit too. And if you're going to make a public benefit called a voucher available, it has to be publicly available to everybody. And of course, it can't go without notice that some groups seem to be more vulnerable than others. Children with disabilities, children whose first language is not English, and also there seems to be particular vulnerability to children and families who identify as LGBTQ. And that's because of policies around religion and the religious schools participating in those voucher programs. So I've covered a lot of ground, but I'm going to stop there and entertain your questions.
Thank you so much, Dr. Mead. This has been quite informative and an incredible resource. We do have a few questions for you. Can we start with this one, which is, would you please further discuss the implications of the Lubienski study regarding race and class? Making the apples to apples comparison means taking out students of color and lower income students from the student performance data.
No, it doesn't mean taking them out. It means comparing folks who have the same characteristics. So it doesn't mean taking them out, it means keeping them in. So looking at someone who shares the same characteristics of race and class in a public school with someone who shares the same characteristics of race and class in a private school.
Thank you. I think you've addressed this in a lot of your presentation, but I'll just give you the opportunity if there's anything more to say on it, which is, are you saying that private education is not accountable to public values? And I do think you've gone through a lot of that, but is there anything else you might want to add to that?
So what I'm saying is that we don't hold them accountable in the same way. And if we value the way that we hold our current public system accountable, then I think it's part of the debate around whether or not we want to fund private education, about whether or not we're holding those schools sufficiently accountable for those public funds. So certainly all education, I'm a professor, right? All education, it doesn't matter where the education comes from or who does it, all education is valuable. You know, it's kind of like I joke with my students sometimes about, you know, I'm not going to talk you out of reading something. You read whatever you like to read. I'm going to assign some things, I'm going to recommend others, but you go ahead and read as much as you like. That's a good thing. And all education is a good thing. But what we're talking about here is how are we going to make sure that we have a minimal, a baseline universal education for all students, and how are we best equipped to do that? Over time, we have used the public education system as a way to create that universal education. Now, again, with all kinds of holes and problems that we have to address and that we'll always have to address. But what we do know, with over 20 years, almost 30, well, it'll be 30 years, actually, we might have had the anniversary now that I think about it, 30 years of publicly funded private education. As one of my friends says, if it was clear that that shift in governance structure produced better results, that would be a very clear research result, and it's not. And so I think what we have to say is, are we willing to let go of the various kinds of accountability provisions that we apply to public schools and not have them apply to private schools, especially if we're creating mechanisms for a greater and greater proportion of students to be educated privately.
Thank you. Another question is, what are your thoughts about where public school funding will be headed in the near future, especially considering the recent Supreme Court decisions like Montana and Espinoza?
Well, we're waiting on Montana. It'll be, I'm waiting. We'll see. I think we're all in a holding pattern. We saw in 2008 and 2009 and right afterwards the huge impact that recession had on funding for public education in particular. And I think there's great concern among many that what we're facing now as a result of the crisis with the pandemic may have a similar kind of situation happen. So I think it's never been more important to think about public funding and how we're going to fund education. You know, the problem is that we're likely, frankly, because of the effects of this pandemic on children and their learning and the trauma that some children may have experienced as a result, we're going to need more educational funding, not less. So I'm really hoping that all levels of government recognize that and provide the investment that's necessary for our children.
And I don't know if you're still sharing your screen, but you may want to take it down. So,
okay.
Okay. And another question that's popped up is, how is it still legal when the voucher funds to private schools are now higher than the funds to public school children? We are no longer serving the public good and access.
Well, to answer that particular question, you have to understand, this is where it gets really complicated. You have to know what state you're in, and you have to know what your state constitution says about education and about public education, and how that education should be funded and whether or not that's explicit in your state constitution. And you have to know how the voucher program is funded in relationship to, and what the interplay is between the funding for private education and the funding for public education. And that can get really, really complicated. When I give this talk in Wisconsin, I often have a series of slides that attempt to unpack that complexity here in Wisconsin, but it's really hard to do because you have to have kind of all of these different interactive pieces of data in order to understand how this all works. As I mentioned earlier, when states have upheld the laws, it's because they've said that it's a discretionary funding. It's not mandatory, it's discretionary. And that the litigants in those cases didn't make the claim that funding of the choice of the legislature to fund private education had meant that they had neglected their obligation to fund public education. So unless and until we get some cases that suggest that, and in fact where a Supreme Courts find that to be the case, that's how they can continue to do this. So understanding whether that's proper or not, I mean, these are always political issues, so whether or not they're open to legal redress. Public Funds for Public Schools just participated in the Tennessee litigation that has enjoined that new voucher program from starting on that constitutional basis. So I suspect we're going to have more litigation to try and figure out how all that works together. And it's likely to be state by state by state by state.
Brianna Nami, like I'm sure many of our viewers, wants to thank you for your presentation. And she asked, in your assessment, what are the most urgent privatization threats that have emerged and how should they be addressed? And she's thinking the shock doctrine responses and also related to the COVID moment.
Yeah, I agree with that. I mean, I think what's clear, and I mentioned that, you know, we had this huge divestment of public education after the last recession, and I don't think it's a coincidence that that was also coincided with this huge increase in the number of states enacting voucher and voucher-like laws. So I think what I hear in your question is the recognition that folks use these kinds of crises as opportunities to insert new policies. What I think is really interesting, and I think it requires vigilance on our part, is that all of these voucher programs, or nearly all, I shouldn't say all because I haven't checked lately, but nearly all were enacted by means of what we call an omnibus bill. So a bill that has a whole lot of stuff in it. It doesn't just have one thing, it has a whole lot. In Wisconsin, they were in omnibus budget bills. So when you have that big budget bill, that means that your representatives that you send to the legislature only get one vote, and it's one vote for everything, right? It's one vote for how you're going to fund schools and prisons and parks and roads and everything the state government does in one vote. And there haven't been standalone votes, an up or down vote on the issue of vouchers alone. And so a lot of these programs are placed into those big omnibus bills, which creates political pressure to vote for them because of all the other stuff that's in that bill. So I think it requires vigilance on our part to call that out, because if the idea is a good idea, it should be able to withstand the sunshine of transparency, in my view. And it also gives us an opportunity to have that debate, which I don't think we really had, about whether or not we're comfortable with buying privatization by diminishing publicness in those systems.
Thank you. And I want to just also note for Brianna and others that we will be having another webinar on that topic specifically on June 4th. So please go again to pfps.org and you can go to the contact page to sign up to get more information about that webinar. Another question here from Brian Kelly. He wants to know if you think we'll see more instances of public money going to private schools as an outcome of those cases that you've talked about. Do you think that will be a likely outcome, the Supreme Court cases that are currently before the court?
Here's where I am always at war with my Pollyannic nature. I want to hold out hope until the very last second, until somebody smacks me in the face with it. I don't know. I think it will be interesting to see. I mean, that particular bill, that particular case, the issue is subsumed in a broader issue around the relationship between state constitutions and prohibitions against direct aid of religion and the federal Constitution and the Establishment Clause of our Constitution. You know, the predictors say, you know, everybody knows how our court is currently constituted, and so that suggests that it may go their way, but we just don't know, and I think we're going to have to wait and see. I think that to the extent, again, that you can be very vocal in your states about what is happening and what is not, and I mean, I think this might be an opportunity for advocates to make a kind of a very kitchen table kind of argument, right? So when a family's budget is squeezed, you let go of the luxuries and you focus on the necessities. And state legislature, I think, maybe we need to remind them of what public schools are, right? They're the necessity under a state constitution. And those other programs are the luxuries. And that perhaps we push in this period of time to remind folks that we need to protect those necessities as we consider making cuts. And that might even motivate legislatures to think about, you know, I don't think it's realistic to think that anybody's going to back away from the voucher programs that are in existence. I don't think that's going to happen, but perhaps they will freeze them until we can get through this crisis. But that remains to be seen, of course.
And along those same lines, for those who are interested in knowing more about or advocating, as you're talking about now, about the importance of public education to democracy, do you have resources you would recommend and as to things that they can refer to and how they might message that to others?
Well, I will give a shameless plug right back to you. I think the materials that you have created on the website do a wonderful job of making those arguments and laying out the arguments and giving a variety of resources. I think you also look at, there are a number of public education advocacy groups that are not only national but also state level ones. I know that here in Wisconsin, the Wisconsin Public Education Network is really, really active and does a great job of creating resources and even training people to show up at hearings and to make cases at hearings and how to really be an advocate. And I think what all of those efforts show, whether national or at the state level, is that they can make a difference. And in fact, we've seen a difference that they've made here. And I think more than ever, it needs us all to be the champions for public education. And so that means that we're going to have a lot on our to-do list and we're all going to be tired still, but I think that's what's necessary.
We who believe in freedom cannot rest, right?
That's right.
Do we have any data by race about families that take advantage of vouchers and similar privatization programs? And what are the implications if participation is significantly different by race and socioeconomic class?
Well, it kind of, again, depends on the kinds of programs that you're looking at and where they are and what the requirements for eligibility for a family are. So the early ones that started, because of where they started and the eligibility requirements, you didn't see, you don't see a big difference in terms of for example, in the Milwaukee Parental Choice Program, the racial makeup of those who exercise the voucher because of the demographics of the community as a whole. And so you have to put all of that kind of thing in context. I think we do know, we have some really good data that shows that even in vouchers that are calibrated on income, it tends to be those closest to the edge of that income limit. In other words, they're almost not eligible. Those tend to be the people who take advantage of that. And of course, you have a number of systems where the kids who have particular, especially high cost special needs are likely not to be exercising those vouchers.
Thank you. The final question, I think we are towards the end of our hour. Let me just ask you, why is it necessary, this is Peter asking, why is it necessary to have the federal government involved with public education? Why don't we just leave this to the states?
Well, it's an interesting argument. I mean, to be frank, that was the argument of those who were on the losing side of Brown versus the Board of Education. And they argued that it was a states' rights issue, leave us alone. I think over time, what you find is that the Congress has this authority in the part of the Article 1 that says they can promote the general welfare, right? And then you also have the authority that I mentioned that comes from the 14th Amendment. So I think over time, although the federal government has never been so instructive in terms of a national curriculum as many countries have, what we do have is as kind of three buckets of laws at the federal level. So one group of laws are what I call general funding legislation, and so they create pots of money for good things that Congress thinks would be a good thing to have happen. And so that pot of money is created, and states can then, or sometimes local school district can compete for a piece of that special pot. The next are what I call conditional funding statutes, and those are statutes that are really like the non-discrimination statutes that you saw there that said, if you take federal money, you can't do these bad things. And these bad things are like discriminating on the basis of race, for example, discriminating on the basis of sex. If you take our money, you can't do this bad thing. You can't, or the Family Educational Rights and Privacy Act. If you take our money, you have to allow parents access to their kids' records. You can't do the bad thing of not letting them see what their kids' records are. And then the third group of federal laws are incentive funding statutes, which say, here's a pot of money and you can have it, but only if you agree to follow all of our rules. And that's IDEA, and the Elementary and Secondary Education Act are both in that group, where they create this big, huge, attractive pot of money. And of course, over time, states have become very dependent on that money. So now all 50 states take it, and it's unlikely that any would turn it away. But the philosophical question of why does the federal government just get out, I think it's because, again, we recognized at some point that we couldn't tolerate some of the differences that happened by a full-on states' rights approach.
Well, Dr. Mead, I cannot thank you enough for being such an incredible resource for all of us here today, and hopefully for many other people who will be able to watch this webinar later. This is an incredible gift. So thank you for being here with us. I want to thank all of the people who participated and who asked very thought-provoking questions. Again, I want to remind all of our participants to please go to our website, pfps.org. And please sign up so you can get information about our future webinars. We appreciate you, and thank you so much. Take care.
Thank you. Goodbye, everybody.